Let's talk about defense strategies in domestic violence cases. Now, there are a couple of things that we commonly see as helpful defense strategies, so I want to go through a couple of those and just kind of give you an idea of different ways that we can approach a defense strategy on a domestic violence case. The first and easiest one is general denial. So if someone is saying, hey, this thing happened, and the other person is saying, no, it didn't, what you would typically think of as a he said, she said situation, our approach is general denial. Now, it really supports our case if we have additional information or additional evidence to support our general denial. And we'll go into kind of what types of evidence are useful in domestic violence cases in a moment. But general denial is the most common. There's also situations where the named victim may be making up a story. So there have been cases that I've worked on specifically where someone gets injured in some way that is not related to any kind of domestic argument whatsoever, but then later on someone calls the cops and said, oh, I got this injury from them. I've seen situations where someone was involved in a skiing accident and then later on that day they got into an argument with their significant other and then reported that their injuries that they had from previously in the day were caused by their partner, which was blatantly untrue. There are a number of different times when we see people calling the police trying to get their significant other in trouble for injuries that were not caused by that person. In that case, we can say this was either an accident that was caused earlier in the day, or we can say that this is a blatantly untrue fact. One of the more common defenses that we see, though, is the defense of self-defense. And self-defense is an especially strong defense in domestic violence cases because it's what we call an affirmative defense. An affirmative defense means the district attorney has to prove elements against a defendant. So they have to prove every single element beyond a reasonable doubt in order to get a conviction at a jury trial. With an affirmative defense, it raises the bar or raises the standard for the district attorney. So not only does the district attorney have to prove every single element of the offense, but they also have to disprove the act of self-defense. So in other words, if we have a case where one person is saying that person shoved me and the other person said, well, they shoved me first, we could claim self-defense. Especially what we see a lot of the times is we'll see common self-defense telltale signs are defensive wounds. So a lot of the times we've seen, often we see a male and female relationship where the male will have a bite mark on his arm and he'll say that the female was the initial aggressor and should be charged with domestic violence. I cannot tell you how many of my female clients are charged in this way, but what I can do is show that defensive wound, the bite mark. Often what that does is proves self-defense, because in a domestic violence situation, if you, for example, if the man was actually trying to hurt the woman by wrapping his arm around her throat, one of the best defensive moves that woman can do is to bite down on the arm to get him to release. Now, obviously in that situation, she is not the initial aggressor, she's defending herself. The injury is difficult because law enforcement may not see injuries on her but sees that bite mark, but in that case we can use the affirmative self-defense claim. Now, if this were to go to trial in this hypothetical example, then the district attorney would have to prove not only that the woman caused the injury to the man, but that she also did it and it was not an act of self-defense. So self-defense is a very, very solid defense strategy if we have the facts available to us to use that approach. Other things that are really helpful when we're forming defense strategies for domestic violence cases is additional evidence. So video recordings, audio recordings, text messages, all of those things are very, very helpful to us as a defense firm because we can use those to not only have a he said, she said situation, but to have actual facts showing that our claim of self-defense or general denial is correct. What I recommend is anytime that you're in a situation where you're feeling uncomfortable or nervous and you think that there may be a potential for a domestic violence situation, always record, because you want to make sure that you are preserving any evidence that could eventually protect you if needed. Now, obviously, we don't want people in these situations, but if you ever find yourself in a situation like that, take videos, take pictures, make notes right after, make sure that you're doing everything you can to protect yourself, and ultimately call an experienced domestic violence attorney to help guide you through this process if you do unfortunately get charged with an act of domestic violence.